to another matter. On the 6th of September, the Chair of the Intelligence Committee, Mr Khalil, wrote to the Minister for Home Affairs asking why on the relisting of 3 terrorist organisations, various Islamic State and Boko Haram groups, the Minister for Home Affairs failed to provide her endorsement for that relisting. The department replied on behalf of the Minister, I believe on the 11th of September, and advised that due to an administrative error, the Minister did not provide advice in support of that listing. Can I ask how this administrative error occurred?
So I'll get the team to come to the table, but my understanding is that it was an administrative oversight where the agreed procedure in relation to the listing of terrorist organisations was not followed to the letter. It was an oversight on the department's side. We take full responsibility for that. It was an administrative oversight.
So, what usually occurs in this process which did not occur? Is there a standard draft letter provided to the Minister to sign that the department failed to do? Where did this error occur?
Yes, there was supposed to be prior correspondence with the Minister's office in relation to it, and that did not occur, Senator. So that's our mistake.
So the department didn't initiate the correspondence it was supposed to under
correct.
the listing process with the Minister's office?
That's correct.
How did that occur? How did that oversight occur? The department was able to manage it in some previous listings, but not on this occasion. Was someone on leave? Did someone just forget? How did it happen?
Senator, it's Chris Field, the First Assistant Secretary for Counter-Terrorism. The error was a human error, and the process is fit for purpose. It is, as you described, Senator, appropriate for the listing and relisting of our terrorist organisations, and we have continued that process subsequently. And simply that it was a simple human mistake at the time.
And it's also worth noting, Senator Patterson, as I understand it, this error had no impact on the legality of the Attorney-General's consideration of the legal threshold for listing under the Criminal Code.
Yeah, I'll come to that. Why is it necessary for the Minister for Home Affairs to provide their endorsement under this process?
Senator, because we are responsible for policy in relation to counter-terrorism. We also are required under part of the process to engage with communities and to look at the intelligence and all of our and engage with portfolio agencies, in particular, as you can imagine, ASIO, in relation to that. Who don't have a policy function, we do, so we engage with them. So there's dual equities in relation to the Attorney and the Minister for Home Affairs here, and we carry forward those equities on behalf of our Minister, who has policy responsibility.
So Minister Waters just asserted that it wasn't legally deficient, the fact that this letter was not provided. Have you sought advice to make sure that's the case?
We have advice that it is not the case because the Attorney is responsible for the Criminal Code provisions around the listing, and the listing is made by the Governor-General.
Could you provide that advice on notice, please?
Senator, I don't believe we're able to provide our legal advice.
On what basis?
On the basis that it goes to some of the... I'd have to take it on notice, but I'll check whether we are able to provide a précis or not in relation to that.
And Senator Patterson, you well know that legal advice received by a client, in this case the government, is privileged.
And you will know, Minister, there's a process if you wish to claim public interest immunity to not provide evidence, and I'd be happy to consider, I'm sure the committee would consider, any public interest immunity claim made by the government.
So I think Mr Smythe has taken it on notice already, and that will potentially lead to a claim of public interest immunity.
Thank you. So noting that in your view it's not legally deficient, it does appear to be deficient from a policy point of view because that input of those agencies was not considered in the process. Is that right?
No, Senator. The input was made available to the agency. It was just made available directly to the Attorney-General's department rather than through our minister.
Is that how it normally happens, or is that
No,
done?
it's not.
Right.
As
so-
I said, there was a process deficiency on our end. We've rectified that to ensure that it will not happen again.
I just want to explore that a little bit further, though. How did someone know to provide that advice direct to AGD if the normal course of events is it's to be provided by the minister, and how wasn't it picked up at that point that this is not the correct process?
Senator, as I mentioned earlier, it was a human error, and it was essentially people working to get the listing progressed, and in that process, that information went to attorneys in terms of a temporal event, not in accordance with the process. It was a human error.
Did this happen because this particular listing was done under some time pressure? This relisting was done under some time pressure?
Senator, we are aware of the schedule for relistings, and that is a deliberate process. It's very much in partnership with AGDs and with our minister's office, and it was simply, as mentioned before, Senator, a human error of our sequencing and the temporal arrangements.
When did the department first identify the human error?
Senator, I'll have to take that on notice.
Okay. It's my memory, I don't have the Attorney-General's submission to the Intelligence Committee in front of me, but it's my memory that these regulations were issued quite close to their expiry under the provisions of the Criminal Code, which they lapse after 3 years. That does indicate there might have been some time pressure in getting this done. Is that right?
I'll have to check and get back to you, Senator. We've taken that on notice.
Okay. Isn't this process stuff up, this human error, entirely foreseeable given the machinery of government changes that were made after the election, where instead of having just one minister responsible for this process, we now have two ministers responsible for this process? I mean, we've previously seen in estimates the time taken for ministerial consideration of terrorist listings and relistings has blown out really significantly. This is a self-evident and foreseeable error, isn't it?
Senator, I don't believe that there's any problem in terms of the timeframes here. We have not missed relistings of organisations at all. We work back from EXCO meetings and also the expiry of the listing, the 3-year listing. So I don't believe there is any problem in relation to the agreed process.
Senator Patterson.
And for the other matter, in relation to machinery of government changes, that's not something that's within my purview to
Just a
comment
final question on this matter, then I'll return the call to the Chair. There is a bill before the Parliament right now in relation to hate symbols, which contains within it a provision that ends the sunsetting of the listing of terrorist organisations. Is that necessary because of those machinery of government changes and the new messy process? I mean, it will reduce significantly the workload for the ministers. They won't have to relist organisations. They'll only have to consider new listings.
Senator, I would refer you to the Attorney-General's Department, who have responsibility for that.
Okay, thank you. Thank you, Chair.
Thanks.